Okay, I think we're about ready to begin. It's 12:30 Eastern. I want to welcome everyone to today's Bressler webinar, the latest in our webinar series. This is on FINRA Expungement. My name is David Hantman, and I'm a principal in the Bressler New York and New Jersey office. I coordinate and oversee the Bressler Expungement sub-practice, and we're very excited to present this on expungement here today. I see a lot of very familiar names on the attendance list, so thank you for participating. We will be giving CLE credit, so listen carefully for the codes that we'll mention throughout the presentation. Bressler is in a unique situation for expungements because, as you know, we represent a lot of brokerage firms, but we also represent during the course of our representation, individual financial advisors in expungement, so we can really provide a unique perspective on all different aspects of expungement, and we plan on doing that here today. There has been, as you know, an increase, a pretty significant increase in the number of expungement filings over the last couple years, but there have been some proposals and rule changes that we'll go through that will impact expungement going forward. We conducted a review and analysis of all Bressler awards in the last year or so, June 2019 to June 2020, and we found that approximately 84% of awards through hearing that Bressler was involved in involved some aspect of expungement. So, it is prevalent in different customer litigation, standalone expungement claims, and it's not something that's often highlighted in the news. It's kind of difficult to follow updates, but the group on the panel who I'll introduce in a minute, all follow expungement very closely, work on expungements on a daily or near daily basis, and we try to provide updated information through our website and client alerts, and we'll continue to do so. Again, those client alerts, we'll send them out, put them on our website. We only have an hour for this presentation, so we'll get forward in introducing our panel. We're going to provide an overview of the expungement process, including the rules, and I just want to clarify here, we're going to focus on customer complaints expungement. There are different things, different disclosures that can be expunged. We're not going to focus on those other things because they're really not that prevalent. We're going to focus on customer complaints, go through the rules. We're going to go through the mechanics of a claim, and again, try to represent our perspective from the firm perspective, from the FA perspective. We'll go through some changes over the years. There have been some significant proposals, but change has been very slow. There's one significant rule change that's going into effect in a couple weeks that we'll discuss. And lastly, we'll discuss how we're moving forward, what trends we see, and what we expect in the expungement space going forward. I'd like to introduce the panel. First, I'm joined by three of my colleagues from the Alabama office. First is Andrea Green-Wells. She's a principal in the Alabama office. And she is in our financial services group, again, works very closely handling expungements. The next is Joel Everest, another principal in our Alabama office. Again, he works on an almost daily basis handling expungements. And last but not least, Sarah Yates, an associate in our Alabama office who also handles expungements. So why don't we move forward with the presentation? I'd like to introduce you to Andrea Green-Wells, who's going to provide an overview of the expungement process, including some of the rules.
Good morning. Thanks, David. I want to start us off, as he said, with just sort of the general landscape with respect to rules governing an expungement proceeding. So to get started, we'll discuss FINRA Rule 2080, which, as many of you know, has been around for quite some time and is where you start when you're handling a case for expungement. So in general, one of the things that the rule offers that some people may not always consider is the fact that you can file a claim for expungement in court or in FINRA arbitration. One thing typically that we see is that the cases are generally filed in FINRA arbitration. Certainly, if you proceed in court, you want to consider your jurisdiction carefully. As I know, many courts are unfamiliar with arbitration generally, and much less so with expungement. But if you do move forward with a standalone expungement proceeding in arbitration, you will end up in court to confirm that award. And in doing so, you have to name FINRA as an additional party in connection with confirming the award. And FINRA does have the option to waive their participation in the court proceeding, and they will do so pursuant to Rule 2080 if they find two things with respect to the expungement proceeding. First, that expungement is meritorious, and second, that expungement will have no material adverse effect on investor protection, the integrity of the CRD system, or regulatory requirements. Some people find this provision to be an independent ground for expungement, and Rule 2080 provides 3 grounds that are commonly used in support of a claim for expungement. But you can argue the advisability of that approach depending on your case, depending on the facts. But you more typically see the 3 grounds for expungement that are set forth in Part B1 of that rule. And those 3 grounds are on the slide deck. You can see in front of you. The first is that the claim, allegation, or information is factually impossible or clearly erroneous. The second is that the registered person was not involved in whatever activity gave rise to the claim. And then the third is that the claim, the allegation, or information is false. And as many of you know from handling these kinds of claims before, this is a high burden to meet. It's not easy to satisfy these grounds, although you only have to satisfy one. And that's one thing that you have to take into consideration as you decide whether or not to file a claim for expungement on behalf of a broker. We certainly carefully vet claims before we file them, and we're selective, but we certainly have a high degree of success when we do actually file the claim for expungement.
Hey, Andrea, I just want to state here that we do have a chat that's open through the app, so if anyone wants to submit questions, we will try to address those questions as we proceed. And Andrea, can you just explain, I know you went through the grounds for Rule 2080. Have you, in your practice, in your experience, noticed any significant difference between the different standards under Rule 2080 in terms of how arbitrators apply them?
I think generally what you see is that really there are 2 grounds for expungement. If you consider the argument that the claim is false, it's really synonymous with the claim being factually impossible or clearly erroneous. Often, if it meets one ground, it's going to meet both of those. But then certainly the claim that the registered person was not involved is an entirely different standard, and something that if you do have those facts to support, will generally make a fairly strong claim for expungement.
Great, thank you.
Sure. So moving forward with respect to the rules that are in place governing an expungement proceeding, we have expanded FINRA guidance that came out in September of 2017. And in connection with the guidance, FINRA also adopted some new rules that really govern procedural requirements for expungement. So I'll cover the expanded guidance first, but it's, I think, interesting to note, and certainly a practice point for anyone handling an expungement claim. Although this is called expanded guidance, it is, in fact, really a list of rules for arbitrators to follow, and FINRA arbitrators are trained to review the expanded guidance carefully and consider each of the items within it. So I'll cover them briefly, but as FINRA did issue the expanded guidance, they made it very clear that expungement relief is extraordinary in nature, and within the guidance they reminded arbitrators of the importance of their role in maintaining the integrity of the CRD system. So one of the key points of the expanded guidance was focusing on the importance of allowing customers to participate in the arbitration process. Many times, an expungement claim is a standalone FINRA arbitration, and in some cases, the arbitration is a case where the broker files it against the brokerage firm as a non-monol, essentially, defendant. And in that situation, the customer who actually complained about the broker or who filed an arbitration involving the broker would have no knowledge that the expungement was being sought. So this expanded guidance ensures that customers are provided with notification of the expungement claim and makes sure that customers are allowed to participate if they want to participate. And the guidance makes clear that arbitrators should allow a customer to come testify if they'd like to in the arbitration, the expungement arbitration proceeding. They can cross-examine the broker. They can make an opening statement, a closing statement, and generally participate as if they're a party to the proceeding, even if they're not.
Hey, Andrea, this is Joel here. I just wanted to raise the topic. How often are customers participating in expungements in your cases?
I think generally they do not participate, but I know that from time to time we do see a customer who is perhaps very passionate about the arbitration that they filed against the broker come in and participate, and in those cases are exceptionally tricky. What about you, Joel? Have you seen that come up?
You know, it definitely happens. It's pretty rare, I think, but not totally unheard of. I've seen a stat that 13% of expungement cases involve a customer actually participating and appearing in the hearing. And that number, 13%, feels about right. I haven't done a deep dive on my personal cases, but that feels about right from my experience. So fairly rare, but it does happen. And like you said, it's usually folks that are pretty passionate about their claim. And it's usually, or I take that back, it's always the customer by him or herself without an attorney, in my experience. Is that what you've seen? And I'll open up to David and Sarah too if they have other thoughts on that.
I have seen attorneys from underlying customer arbitrations appear with their customers later on in expungements, but again, that would be exceedingly rare. I agree with that 13% number in my own personal experience, and most of the time, like you said, it's usually the customer calling in if it's a telephonic hearing, and sometimes without notice. Sometimes no one knows the customer's going to call in until the day of the hearing. So like Andrea said, a lot of surprises, a lot of curveballs when that happens. So it's important to be prepared for that.
Yeah, and Sarah, I would agree with that. The 13% number that I've read, in my experience, that seemed a little high. I've had a much lower incident. But I think the important thing here is that everyone is aware in advance of the expungement that this is a possibility, so there are no surprises, and the financial advisor or the firm, is aware that this is a possibility. It could happen, and to be prepared by prepping in advance for that eventuality if it does happen.
Right. I think it's just par for the course in FINRA arbitration. I think the overarching rule can often be just expect the unexpected, and you'll be prepared as much as you can be. So going back to the expanded FINRA guidance, there are two other points that I wanted to highlight that are incorporated within that guidance. And the first is that the panel has to review the broker check report for the broker who is seeking expungement. And second, the panel has to confirm that this is the first time that the broker has sought expungement of this complaint or arbitration. You don't get a second bite at the apple. So I'll move forward to FINRA Rule 12.805 for customer disputes and 13.805 for industry disputes. And this is the rule that was adopted along with the issuance of the expanded guidance we were just talking about. And if you look at the rule, it's a lot shorter than the expanded guidance. So don't be deceived in thinking that you only have these few requirements to meet. You actually have all of the requirements within the guidance. But just briefly discussing these requirements, first you have to have a recorded hearing session. Expungement cannot be decided on the papers. Second, the arbitrator has to review any settlement documents if the expungement is arising from an arbitration claim or a customer complaint that was settled. And arbitrators are trained to focus on the amount of the settlement, certainly with the implication that the higher the settlement, the more difficult it should be to get expungement. Although I know we've all had success with expungements in cases where the settlement was quite high. Certainly depends on the facts of the case.
And on that point, going back to the 3 primary factors, the subsection B, if the rep wasn't involved with the sales practice allegation, I mean, I'm going to make the argument that the settlement amount really doesn't matter. It could be $10 million if our person wasn't involved with that conduct. It's irrelevant, but it's still something that the arbitrator is going to look at regardless of which arguments you're making. It's just something you need to argue at the hearing.
Right, and we do see the argument that the broker was not involved, particularly in cases that are product cases, which our firm handles quite often. I can recall a product case where the broker wasn't involved at all, and we got expungement even though the settlement was for upwards of $1 million. So it certainly can happen, despite what you might think is a large settlement. The other factor to consider for arbitrators as they're reviewing settlements is the amount of the broker contribution, if any, because sometimes brokers are required to come out of pocket themselves for a portion or sometimes all of the settlement amount. So arbitrators are going to be looking at that. Finally, or not finally, but second to last, arbitrators can assess and should assess all the forum fees for a hearing session against the moving party if the hearing is solely devoted to expungement. And finally, the arbitrators are required to explain their rationale for their decision granting expungement. And this is probably the most important piece of this rule, something that as a practitioner you really should focus on, because arbitrators don't always know how to express their rationale. They're not judges, they're not necessarily trained in drafting opinions. So something that if you sit in our seat, you might want to provide to the arbitrator in the form of a proposed order or perhaps a letter submission, just making very clear to the arbitrator what the grounds for expungement are and the facts that support the expungement. So that's the high level.
And Andrea, on that, I've had one circumstance, I think it was back in 2007, when the rules changed and arbitrators were required to provide some factual recitation or basis for the expungement. But now I think the FINRA staff does a pretty good job in the back and forth with the arbitrators and telling the arbitrators that they're required to provide some basis. And I've seen it everything from one sentence to a couple pages. But it's not really an issue. But certainly, if we want the arbitrators to adopt our arguments, it is helpful to either summarize them on the expungement hearing or provide some short proposed factual findings.
Yeah, and I think it's most important in probably your more complex cases. I know the last one that I handled, it was actually a complex tax issue, which ultimately had nothing to do with the broker, but the arbitrator was intent upon trying to grasp all of the facts that supported expungement and in these complex tax issues. So, like I said, it totally depends on the facts of your case, but can be very important.
We do have a few questions I saw popped up. A couple of them are about the notice that has to be provided to the customers, and Sarah is going to address that in more detail here in a few minutes. So we'll definitely get to those and talk about that issue. And then the other question was about a denied customer complaint that's still listed on broker check. Could that be removed? And the answer there is yes. If it's a customer complaint, as long as you're able to comply with the other requirements of the expanded guidance and meet the criteria under the rules, that is something that would still be eligible to be expunged.
All right, I'm going to address the mechanics of a FINRA expungement claim. And as Andrea mentioned, in Rule 2080, an FA can seek expungement either in court or in arbitration. Court's generally going to be a more costly, drawn-out process. You also risk having a court who's unfamiliar with FINRA, customer claims, and the expungement process in general. FINRA is the primary way that we see brokers requesting expungement. So within FINRA, there are two methods. The first way is a request made as a part of a customer arbitration. So this is when a broker has received a disclosure on his or her record because a customer has filed a claim in FINRA against the firm and or against the broker. And as part of the firm or broker's defense of that claim, expungement is requested on behalf of the broker. And in that case, if arbitration proceeds to final hearing on the merits, that expungement request will be decided by the panel of arbitrators together with the customer's claim. So the final award will also, in addition to ruling on the customer's claim, will also contain a ruling on the expungement request. If the arbitration settles before the final hearing, the broker still has the opportunity to have his expungement claim heard in front of the same panel. The broker can request that the panel not be dissolved, even though the underlying claim has been settled, and he can still have his day in court, as it were, in front of that panel. And then again, the award will be issued on the expungement request. Now, the second way, and what we're really focusing on today, is a standalone request for expungement. FINRA refers to these as straight-in request. And this is when a financial advisor files a totally separate arbitration claim, files his own petition or own statement of claim for expungement of a customer dispute. So let's walk through that process. The first document the financial advisor will file is a statement of claim. This is an important document where he has the opportunity to lay out the facts, what really happened in this customer dispute, and most importantly, why it meets one of the bases under Rule 2080 to be expunged. Now, in every FINRA arbitration, there's both a claimant, who will be the FA, and then there's a respondent. And the respondent is usually the opposing party. However, these types of expungement matters are typically not adverse. So the financial advisor can name either the firm or the complaining customer as the respondent. It's a little tricky with FINRA jurisdiction over an individual who's not registered with FINRA, and in general, best practice is going to be naming the firm. And another aspect of the statement of claim is that financial advisors often request a nominal amount in damages, say $1, $50, something like that. And the reason that's done is because under the current FINRA rules, a small amount of damages like that enables the financial advisor to have a sole arbitrator hear his expungement claim, and it also greatly reduces the amount in fees. Now, some of that is going to be changing, and we'll be talking about that soon, but that's typically the initial pleading in a FINRA expungement claim. Now, the firm, of course, then files its answer. And again, if this is a non-adversarial type of claim where the financial advisor is simply seeking expungement of a customer dispute that perhaps the firm denied or didn't believe was meritorious anyway, firms will typically be neutral to this type of claim. This is not always the case, but it typically is, from what I've seen, that firms will not oppose this expungement. However, the answer is still an opportunity to clear up factual allegations, make sure the arbitrator gets the facts straight, and then provide any defenses. And then, of course, if the firm does not believe that the expungement is warranted, then of course they can expose it. They can oppose it in their answer if there are reasons to do so.
And Sarah, you mentioned, the FA seeking expungement needing to be FINRA registered. We had a question come in about trying to expunge a complaint for registered investment advisors, SEC registered, not FINRA registered. And I can actually speak to that because I've got the same situation going on right now. Because FINRA maintains the CRD system, in all likelihood, you would be able to proceed with a FINRA arbitration, even if your claimant, even if the person seeking the expungement is not a FINRA registered person. There's a lot of variables in play. If the person was previously a FINRA member, a FINRA registered representative, that's certainly going to help your calls and getting them to allow the forum. If the firm that reported it, of course, if they were a FINRA member, that's going to help the calls too. But in many instances, you are able to still file in a FINRA arbitration, even if you are, the FA is not currently a FINRA registered person.
That's right. I've only dealt with it a couple of times as well. But one of the requirements for the arbitrator to review is the broker's CRD report, this broker check report. And of course, FINRA maintains that. But if the broker is registered with the SEC instead of FINRA, then the IAPD report would be the other document that would be submitted to the arbitrator in that instance. So moving on to the next stage of the process, after the parties have submitted their pleadings, arbitrators are selected. So in a typical FINRA arbitration, the default number of arbitrators is 3. All claims are heard by a 3-arbitrator panel. Now, if there's a claim for a small amount of damages, or the parties otherwise agree to use a single arbitrator, then there will just be 1. But the process for ranking them and selecting them is the same either way. So each party will receive a list generated by FINRA of arbitrators, as well as their backgrounds, their prior award histories, which can be very important to review to see how they decided in prior cases. And then the parties are able to select and rank potential arbitrators and strike the ones they don't want. That's a confidential process. And then FINRA takes the aggregate of the ranked arbitrators and pulls the panel from the highest ranked ones. After that, the parties will engage in discovery. And discovery, well, it's usually the most drawn out part of an arbitration. In expungement, it's typically pretty limited. So what's at issue in an expungement is, of course, the underlying customer complaint. And so the arbitrator will usually want to see the relevant complaint documents. And then, of course, most importantly, if the complaint was settled, then the arbitrator has to review the settlement documents under the FINRA rules. But other than that, discovery is usually not going to be an onerous process. There's going to be, if any party seeks it at all, it'll just be the financial advisor usually. And so while you need to be aware of that, it's not something that usually takes up a lot of time. Then we get to the hearings. There are 2 hearings typically in these types of claims. The first is an initial pre-hearing conference, and that's really your introduction to the arbitrator. That's when you set up a conference call to discuss what date the final hearing is going to be set any other deadlines, confirm the panel of arbitrators, and confirm there are no conflicts or other disclosures that need to be made. And in an expungement hearing, the initial pre-hearing conference is usually not as important, say, as it would be in a more adversarial claim where there's going to be a lot of motion practice, there's going to be a lot of discovery. So we see parties sometimes choose to waive the IPHC, as it's called, and instead submit to the arbitrator a list of proposed dates. And that's also a way to avoid a hearing session fee, which would come with having a call with the arbitrators. And finally, we get to the final hearing, which of course is the most important part, and that's when the financial advisor has a chance to present his case in front of the arbitrator or arbitration panel. And as we've already discussed, really expect the unexpected. Although these can be fairly straightforward, they can also have some curveballs thrown at you. The customer might attend and present his or her case for why expungement shouldn't be granted. Also, arbitrators have wide latitude in what they often may want to review or hear as testimony. So I'd love to hear what the other people in the group have dealt with in their hearing sessions, but I know in one of mine recently, the arbitrator adjourned the hearing because he wanted additional documentation to be provided. So he gave the parties an opportunity to go find that documentation and bring it back. And again, it was all in the name of trying to really understand what the customer complaint was all about, and be very thorough in that. But that really just depends on the facts of the case and what arbitrator you have.
Well, and I can chime in here with the experience as well. I recently had a case where we made our case for expungement, the broker testified, and the arbitrator said, well, I'd like to hear from a witness from the brokerage firm. You know, the brokerage firm is the respondent in this case, and I really feel like I cannot decide this unless I hear from them. So we adjourned the hearing at that time, and I got in contact with the branch manager who was able to testify. I called him as a witness in a second session, and you know, ultimately we got the expungement. But that stems from the expanded guidance that FINRA issued in 2017 that does provide that arbitrators should request whatever it is they need to decide a case for expungement.
Yeah, and I've had similar experiences in a customer arbitration that had settled. We were proceeding with an expungement, and the chair adjourned the hearing because he ordered that the underlying customers appear on the expungement call because he wanted to ask them questions. That's only really happened once, but again, we should be prepared for arbitrators to request whatever additional documentation or request additional witnesses. Before we forget, Sarah, we do have a question that came in that Joel mentioned previously. And obviously we don't have time to go through every stage of the expungement, but there was a question about service to the underlying customers and how you typically do that. I think question was FedEx or regular mail. Can you just briefly walk through how you notify the underlying customer of the expungement petition, of the expungement hearing, and what information you typically provide?
Absolutely. So I think that there are different methods to do this. There's no just one way, but typically the most important information to give to the customer is the expungement statement of claim, which of course lays out the facts from the broker's point of view and why expungement is warranted, and then provides the final hearing information. So if the customer wants to call in, show up to the final hearing, they are connected with FINRA. They know the date and the time of the final hearing, and they can connect with FINRA and either write a letter in, I've seen that several times, or just make a statement, or actually call in or show up at the final hearing to state their case.
Yeah, and Sarah, just from a procedural perspective, I usually send all of my expungement petitions and the notice of the hearing via FedEx, and I get the FedEx confirmation showing that it was delivered to the customer at that address at a certain date, and I submit an affirmation of service to FINRA, and I attach the FedEx confirmation slip as an attachment to the affirmation, just so the arbitrator has a comfort level and everything he or she needs to be confident that we conform to the expanded FINRA expungement guidance.
And David, I think that hits the nail on the head. You know, getting the arbitrator comfortable, doing whatever you can to make sure the arbitrator's comfortable that you've made a good faith effort to make that notification and comply with the rules, because it doesn't specify exactly what you have to do. So, you know, you want to get that arbitrator in a place where he or she feels very comfortable that they can grant expungement if they think it's warranted. You know, there's no technical reason to deny it. And that ties into another question that just came in that involved a situation where, you know, what if the customer is now deceased? And that's another issue that we see pretty regularly. And again, you just want to make that arbitrator comfortable that you have looked into it, and you may know for a fact that the customer is deceased. You know, sometimes we'll provide a death certificate or other sort of verification if we can get it, but that is, you know, in my experience, always been sufficient to get the arbitrator comfortable that, you know, you made your efforts to comply with that expanded guidance, and things like a customer being deceased or things along those lines aren't typically going to be an issue if you're proving to the arbitrator that you've done, you know, your good faith efforts to make it happen. And I think that there was another part of that question. If the claim never went to arbitration, I think that circles back to the question we addressed earlier, where if the claim was denied, is it still eligible? Same answer here. Even if it never went to an arbitration, if it's a customer complaint appearing on the CRD, if you're able to meet the criteria and prove what you need to prove, it is going to be eligible for expungement.
Yeah, and Joel, along those lines, I sometimes get questions. Basically, any customer complaint that is disclosed on CRD and reflected on broker check, in theory, can be expunged. Sometimes you get questions, well, it should have never been disclosed in the first place, or it was a mistake. You still have to go through the expungement process. I've had, plenty of expungements where it was the wrong FA or a team member, or there was an allegation of churning in a fee-based account managed by a third-party money manager. It doesn't matter. As long as the complaint is disclosed and reported, you have to go through the process. All right, so Sarah, we'd like to get to the next section almost, so if we can move forward with the award section. And before I do that, I'm just going to announce one of our 2 CLE codes. This is going to be a really original one. The first code is expungement, EXPUNGEMENT, expungement. Thanks, Sarah.
Great, thanks. Right, so the last part is after the hearing, the arbitrator issues an award. And if the arbitrator denies expungement, that's pretty much the end of the road with FINRA. And like Andrea said, you can't get a second bite at the apple. FINRA does not allow a denied expungement request to be renewed. And that kind of goes along with the question that was asked about what kinds of complaints can be expunged. And yes, settled, denied, withdrawn, closed, no action. There really isn't a criteria for that. But if there has been another award against the broker where expungement was denied, then you're not going to be able to renew that expungement request and have that granted. Now, if expungement is recommended, then we go to the next phase, which is the court confirmation as required by Rule 2080. Part of that is that FINRA must be named as an additional party unless FINRA waives that requirement. So after getting the award, you have to go through this waiver process. Once FINRA waives that requirement, then you file the petition in court, and then once confirmed, that order confirming the award has to be sent back to FINRA. So as we said, this is fairly streamlined procedure, but there certainly are a lot of steps, and it's important to have somebody who knows what they're doing and knows the court, knows the steps to go through in order to make sure that this expungement is filed properly and if granted, gets that dispute off the broker's record.
Yeah, Sarah, along those lines, can you talk about the importance of the court confirmation proceeding in terms of really knowing what documents to file and what court to file in terms of streamlining and moving along the process? Because I know that some jurisdictions it can be very slow.
That's right. It's very important to know the jurisdiction that you're filing in, and certain courts require different processes. Some require an in-person hearing in order to argue why the petition for expungement should be granted, and others, it might just be laying in the docket for a while until you call the court and let them know what's going on. So it's really important to do your research, to know what's going on with the court, and again, to make sure you've properly had FINRA waive its obligation to appear, and so there's no roadblocks in the way once you get to that part. But I mean, all that being said, it can still take several months because that's just how court dockets are. They're often backed up, and so again, that's just sort of part of the be patient part of the proceeding. All right, so with that, I'll turn it over to Joel and David. Thanks,
Sarah. We've had a few more questions come in, which is great. Keep them coming. We're happy to answer. A lot of them are focused on older complaints. A complaint that's maybe 10 years old, which again probably ties in, to an instance where the customer might be deceased. And the questions relate to several topics. One of which is notice. And again, I think we addressed this a little bit already, but basically, it's just that best, a good faith effort is going to be sufficient. There was a reference about, having to hire a PI or something along those lines to really track down. And that's not something I've ever done, not something I've heard of being done. I certainly don't think that would be required. Although at the end of the day, it's coming down to your arbitrator. Can't imagine an arbitrator wanting us, wanting a representative to go that far. It's really just that good faith effort, which is going to be short of that. They also raised an interesting question about Rule 12206, which is the 6-year eligibility rule and how that might play into it. And I'd be interested to hear from the other panelists. That's something that does come up from time to time when you're dealing with older claims. I think there's several ways to sort of attack it from a defense standpoint. My initial inclination is the argument that you're looking at the occurrence or event. That's the rule. If the occurrence or event was more than 6 years ago. So from my perspective, in filing a claim for expungement, the event that's the problem is the ongoing harm to the FA's reputation as published constantly daily, through the present on broker check. So that's, usually my primary argument. It can obviously vary case to case depending on the facts. But the fact that it's sort of a continuing wrong all the way to the present and not so much just focused on the date that the actual complaint was made years ago. Panelists, anything else on that?
Yeah, Joel, procedurally, that comes up sometimes. It's a common question about whether an individual can pursue expungement of a complaint that's more than 6 years. The rule actually provides that the opposing party needs to make a motion, and I've briefed this, and I've been through this a couple times with certain clients. And largely because expungement is not necessarily an adversarial proceeding, a brokerage firm, may not have the incentive to brief the whole issue and submit a motion to dismiss. So that's not too common, but I have seen it. And I've also seen arbitrators sua sponte decide that a claim was ineligible, but that's not a fair reading of the rule because it does require a motion.
Thanks, David. And so with that, I'm going to talk for a few minutes about the history of expungement, because we're going to wrap up by addressing, more of the current trends and where we see things going. But I think to get a sense of where we're heading, it's important to know, where we came from. And in particular, since 2009, it was really the start of an evolution in the expungement process that's still going on today and will likely continue going on for years to come. My personal view is that has been a two-pronged effort by FINRA. On the one hand, to increase the complaints that are being reported and the complaints that are being seen by the public. And on the other hand, the second prong, they want those complaints to stay reported and to not be expunged. And it really starts, we've got a timeline here over the next few slides. It starts in 2009 with a rule change by FINRA that really sets this whole thing in motion. Before 2009, the only way to get a customer complaint on your CRD, on your broker check, was if the registered person was actually named as a party in the complaint. So you had to be up there in the caption as one of the named respondents. 2009, FINRA changed that rule and said that as long as the financial advisor can be reasonably identified from the contents of the complaint, it was going to be reported on the CRD and reported on broker check. So you don't have to be a named party. Your name doesn't even have to be in the complaint at all. As long as you can be reasonably identified, it's going to get reported. Huge change. You know, it resulted in a enormous increase in the number of complaints that were being reported, which in turn, of course, leads to a enormous increase in the number of expungements. So it really sets in motion expungement being a much bigger subject and topic of debate, and therefore various rules and guidance gets proposed to try to address those issues that are being debated. You can see in the timeline, August 2010, another step by FINRA in that first prong to make complaints more reviewable, historic complaints, which were older matters that had previously rolled off, come back on to broker check. So more complaints being listed. And then in 2013, the Public Investors Arbitration Bar Association, the Bar Association for Customer Claimants, PIABA, comes out with a study, they call it a study, asserting that expungement is clearly broken and there's an alarmingly high percentage of expungements being granted. They found a 97% success rate for expungements that they had analyzed, which for some reason was between January 2007 and May 2009. They found a 97% success rate, and I believe they only looked at cases where the case had settled and then an expungement request was made. So not standalones and not cases that went to a final hearing on the merits, and part of that was an expungement request. But they found a 97% success rate, broken system according to PIABA. So FINRA, in response to that study, almost immediately, they issued a press release saying that they shared PIABA's serious concerns, although they did note that the number of expungements granted was less than 5% of the total number of customer disputes. So less than 5% of the cases filed actually ended in an expungement being granted, according to FINRA at that time. Nevertheless, they came out again almost immediately. October 2013, we're still in the same month. They released the first version of that expanded expungement guidance that Andrea went through in detail earlier. This is the first time where you hear that buzzword that expungement is an extraordinary remedy. That's where that came from, this 2013, and they launched some of those measures that Andrea talked about. Jump ahead to 2015, there's another study from PIABA, and it finds a 90% success rate, says more changes are needed. FINRA continues to respond to that study. In December 2015, they created a task force, and June of 2016, you can see they created a new rule that requires links to broker check. So, you know, if there's any registered representatives online here today, on your web page for your firm, you know, there has to be a link to broker check. Again, that's publicizing the complaints, that first prong of FINRA's effort. FINRA continues to add to the expungement expanded guidance. In September 17, there's more added that Andre went through earlier. And then in December of 2017 is really the big one. This is the Notice to Members 1742. I'm going to jump ahead here. Some major proposed changes in 2017 from this regulatory notice. It proposes, you know, we talked earlier about the 6-year time limit. This proposes a 1-year time limit, and that's not an occurrence or event standard. That's more of a statute of limitation that was proposed in 1742. You have to file within a year of the underlying arbitration being closed, or if there was no arbitration, within 1 year of the complaint being reported. That's the proposal. There's a heightened standard proposed. It's the Rule 2080 grounds plus, so you have to prove the claim is false and that the customer dispute information has no investor protection or regulatory value. You have to have a special arbitrator roster, unanimous decision by a panel of 3, cannot opt for a panel of 1, has to be an in-person hearing, which they obviously drafted this proposal before COVID hit, but they require an in-person hearing, and it increases the fees. So that was the major overhaul proposed back in 2017. And then nothing really happened for months and months. They announced this overhaul and then really silence for over a year from FINRA until January of 2019. They issued a status report, which didn't really say anything. It simply said that the changes proposed are in progress and they're still considering options. FINRA's still considering options. In October of 2019, the FINRA Board of Governors approved one of the measures, the special arbitrator roster, but that has not actually been implemented. It was approved by the governors. A rule has not been sent to the SEC. Sitting here today, about 10 months later, it's still in limbo. And that brings us up to today and this latest regulatory notice, 2025, which David can give some more color on.
Yeah, thanks, Joel. So as Joel mentioned, there's been a slow progression of proposals and rule changes, the most significant of which was in December 2017 with the regulatory notice 1742, which our firm was involved working with SIFMA drafting a response. Hopefully that's at least part of the reason that nothing much has happened, I'd like to think. But more recently, in June, and then it was passed by FINRA last month, Regulatory Notice 2025, which is a rule change that becomes applicable for all cases filed on or after September 14th, 2020, so just a few weeks from now. It's going to significantly increase the FINRA fees for expungement, regardless of whether it's a customer arbitration or a straight-in or standalone expungement petition. And I just summarized the impact of this. Currently, under the current rules, the total FINRA fees are typically $300 for a straight-in standalone expungement, and those are increasing to about $9,475 combined for both the individual and the firm. Again, it applies to all expungement requests, not just straight-in requests, and we'll go through some of the rule changes here. One thing that I want to point out is that the new rules will apply filing fees at the time of the request. So, we'll talk about what to expect going forward, but this means that in a customer arbitration, it's fairly standard if the grounds exist in the answer phase for a brokerage firm to request expungement from the individual financial advisor CRD in the answer. That would trigger a filing fee for expungement. So I think that may cause firms to maybe delay the request or maybe gather a little more information, go through discovery to make sure that the grounds are warranted. And that the filing fees are assessed to the party requesting expungement. Again, if we're in a straight-in request, that would be the financial advisor. If we're in a customer arbitration in which only the brokerage firm is named, then the brokerage firm requests expungement on behalf of the unnamed FA, those fees would be assessed to the brokerage firm. And just to break down these fees, the effects on the individual, if we're looking at an individual, a straight-in expungement request, the minimum fee will be $1,575 minimum fee. Again, that's a minimum fee. If for some reason the broker requested expungement and $1 million in damages, the minimum filing fee would be higher based on the chart under FINRA rules, but in most cases it's going to be the $1,575 fee. The other fees that are highlighted in the regulatory notice are the hearing fees, the pre-hearing and the hearing fees. It's $1,125 per session. And this is important. Sarah discussed one arbitrator versus 3 arbitrators. The default under this rule is 3 arbitrators. So if an individual files for expungement, FINRA will assign 3 arbitrators. But there still exists the alternative. If both parties agree to a single arbitrator, then the case can proceed with a single arbitrator. In terms of single arbitrator, I put a little asterisk next to the $450 pre-hearing or hearing session fee. I had discussions with some of the panelists about the language in the rule, and it's not entirely clear. The rule is written with a default to 3 arbitrators. It also references that other hearing fees, if different amounts were requested, would apply for 1 arbitrator, but doesn't specifically address that. So my interpretation, and certainly how I will argue, is that a single arbitrator party should only be charged a $450 fee, but it remains to be seen whether FINRA will incorporate that $1125 fee. And we mentioned before in expungements, it's not always necessary to have a pre-hearing conference, especially when it's going to cost more. So I expect more pre-hearing conferences will probably be waived. So total fees for an individual, depending on the number of arbitrators, is probably going to be somewhere between $2,000 and $3,800, depending on how many arbitrators and if it's waived. Going to the next slide, I know we have a couple minutes left. Maybe the larger impact or a greater monetary impact is the straight-in request for the effect on member firms. FINRA will impose a minimum FINRA processing fee of $37.50, as well as a minimum FINRA surcharge of $1,900. I know Sarah mentioned before you have the option of naming the brokerage firm or the customer. Well, FINRA has made clear in this regulatory notice that even if a financial advisor names a customer, FINRA is still going to charge the brokerage firm at which the broker was employed at that time, both the process fee and the member surcharge. So there's no way to get around that. Current trends and what's next. I know we mentioned these as we proceeded, but I want to point out some of these. There's been a slow progression of changes in FINRA rules. The most prominent was the December 2017, and nothing much has happened. PIABA has issued a report, and FINRA has actually confirmed that it's losing money in these expungement filings when only $1 is requested. So this was really the low-hanging fruit. It was not a substantive rule change. It's a fee rule change that will probably have an impact. We'll see what kind of impact that is on the number of filings. I expect that it may reduce the number of expungement filings due to the costs. Maybe firms take a different approach on supporting a broker in an expungement due to these costs. I mentioned before, it will probably have an effect on the timing of expungement requests, especially in a customer arbitration. Brokerage firms may be apt to wait a little longer towards the end to better assess the case before being assessed the filing fee. One thing to mention, in a customer arbitration, the firm is not going to be double charged a processing fee and a filing fee. It's whatever, and a member fee. Those were assessed at the beginning of the arbitration, so it's not a double charge. But we certainly do expect this to have some impact on expungement requests due to these cost considerations. Again, FINRA is sort of trickling out these rule changes. No substantive rule changes. Joel mentioned the approved rules for the special arbitrator roster that were approved by FINRA in October 2019. We're still waiting on that. Nothing has been done. It's just sort of in limbo there.
Yeah, David, it's interesting. The Board of Governors approved it in October 2019. I had mentioned the FINRA task force that was created back in 2015. So that special roster was actually recommended by the task force almost 5 years ago, and then 10 months ago approved by the Board of Governors, and to date, no action. So that is definitely a recurring theme that we're seeing in this space, that a lot of talk and recommendations, slow on the action.
Yeah, and the other thing that I wanted to mention, the codification of the expanded expungement guidance. First in 2013, the most recent update was September 2017. That's been approved for codification. We're still awaiting that, but I don't see any real impact of that. As the panel mentioned, FINRA instructs arbitrators to follow those, and they're treated as rules. So whether it's actually passed in rule form, FINRA and arbitrators treat the expanded expungement guidance from September 2017 as a rule. They will review a settlement agreement. They make sure the customer is served. All of those are treated as rules. So I think we're out of time. It's 1:30. Thank you everyone for joining us. I hope this was informative. We're available to discuss further, answer any questions. The next segment of our webinars is next week. The ethics of email, best practices for communication in a virtual world. Same time, same place. And last, the code for CLE purposes, another creative one. The second code is FINRA, F-I-N-R-A. And I'd like to thank everyone for joining us, and have a wonderful afternoon and a great summer.
And I know there were a few questions we didn't get to that came in, so we're happy to address those at a later time if anyone wants to reach out and discuss.
Thank you.
Thank you.
Thank you.